Then let's go to James Ballou on the record in BU 2025 TR 1756, State of Kansas versus James Ballou. Jared Regier for the state. You are the defendant, James Ballou. Is that correct, sir?
Yeah, that's me. Morning, Judge Webster. How are you?
I'm good, thank you. And good morning. Mr. Ballou, you are charged in count 1 with speeding 91 miles per hour in a 75 zone. That is a traffic infraction. It does not carry jail time. It has only a scheduled fine if you're to be convicted. Count 2, failure to yield to emergency vehicle is an infraction, and it does also carry a scheduled fine if you were to be convicted. Trying to see the scheduled fine for that is fairly substantial, as I recall. I think it's about $195 plus court costs of $108. That's if my memory serves me correctly.
Yeah, that's what I see here in the citation.
Okay, very well. You do have the right to plead not guilty and set this for trial. You can plead guilty and proceed with sentencing with the fines that we've just discussed. You can plead no contest, which says I don't admit the charges, but I don't want to deny them and take them to trial either. You would still be found guilty, but you would not be admitting the charges. So with those choices, how do you want to proceed?
Yeah.
I would take, go ahead.
No, go ahead. I'm sorry.
I was going to say I can't appoint an attorney, but I can certainly give you time to hire one if you wish.
Well, we'll see if we need to go there or not. Hopefully this will be a little more cut and dry. But yeah, I'd like to plead not guilty to the failure to yield to emergency vehicle charge.
All right, well, I'm going to enter a not guilty plea to both of them just to keep them together.
Okay.
I don't know if you would qualify for diversion. The state, everyone listen now. The state does have a diversion program. If you pay your fines, costs, and a diversion fee, and do whatever else they require you to do, such as if you don't have a license, you get your license. If you don't have insurance, you get insurance. Whatever they require you to do and you agree to, if you complete what you agree to, they will dismiss the charges and keep them off your record. Some people take the position that the diversion, the cost of it doesn't benefit them. Others take the position that it's great to pay a little extra and keep it off your record so it can't be held against you traffic-wise or insurance or in any other situation, security clearances and so forth. If you're interested in that, go to bucoks.gov. That's short for Butler County, Kansas.gov. It's online. You apply online. It's not enough just to apply and think your charges go away. You have to be accepted on their program. You have to watch your mailbox, your regular U.S. Post mailbox, because if you're approved in 2 to 3 weeks, somewhere in there, they'll send you your notification of what you need to do in a contract, and you'll have to sign, initial the contract, and send it back. You apply online, but you accept either by hand delivering or mailing to them the contract. But I'm going to give you a court date. Mr. Ballou, I don't know if you're interested in diversion or not, but you entered not guilty, and you're going to talk to an attorney if you want and see if you need an attorney or so, whatever, that's on you. But the next court date, this will be a bench trial. And when will that be, Destiny? Is that January 7 again? No,
Your Honor. I have December 10th for our next bench trial date.
Okay. December 10th of 25 at 1:30. And that will be by Zoom, but you can always come to the courthouse if you don't know how to finagle Zoom, and I certainly can respect that. Let's see. You do not have to get your picture and prints taken because these are just infractions. Anyone with an A or B misdemeanor or higher, Kansas law says you have to get your picture and prints taken. So some of you will be ordered to go to the breakout room with the officer like the folks right before you did. But in this case, Mr. Ballou has 2 traffic infractions and does not have to go through that process. But you are ordered to reappear at that date and time, or you'll get your licenses suspended probably. Mr. Regier, anything further on this case from the state?
Yeah, just a couple questions. Oh, whoops, go ahead. Sorry.
To repeat, no, Your Honor.
And Mr. Ballou, anything further?
Yeah, can you repeat that URL, the website the domain for the
Oh,
diversion.
okay, all right. BUCOKS.com or .gov. They changed it recently, I think, to .gov.
BUCKOS dot,
Think of the first two letters of Butler County, BU for Butler, CO for county, KS for Kansas, .gov.
okay,
And if you have any problems trying to find that, the county attorney's phone number that you could call is 316-321-6999.
okay,
But they prefer you do all your processing initially through the internet.
okay. So is today really just to enter the guilty or non-guilty plea or no contest? It's not to really present
Today is
the
called
merit to the case or the
right,
frivolous of it?
right.
Okay,
Right, today is what is called the first appearance, where you're informed officially of the charges, the possible penalties, and your rights, such as your right to a trial, and to set the trial date if you want it. So I think we've covered all of that. And then if you had a A or B, we'd need and you hadn't been arrested, we'd need to get you set up for that, but you don't have to do that.
okay. And do these need to stay grouped together moving forward, or is
They
that
don't
something?
have to. They don't have to. I could accept a plea to one and a
Your
plea
Honor,
to
if I may interject briefly,
yes, Mr. Regier.
in this matter, the state is objecting to any bifurcation.
All right. I could, back to you, Mr. Ballou. I could let you take a plea of guilty to one count and not guilty to the other. That would be, as Mr. Regier just said, bifurcating it. And I don't like to do that. And so I generally don't. I just like to kind of keep it together. Now, if we get here on your trial date and you decide, I just want to pursue that one charge, then I will consider that request again at that time. But for right now, I'm just going to keep them both together. It's more of a bookkeeping clerical for
Okay.
me anyway.
Okay. Okay. So the diversion, is that something that potentially, if I do that, that it would make them where they're both off of the record then? And would that
That
be
I think
for this December
I-
10th?
you have, if you're going to do diversion, you have to do that before trial. It's a pre-trial diversion.
Okay.
If you go to trial and lose, then they're going to say no diversion.
Yeah.
So I
And
would
would that take,
suggest, I
would
would
it
suggest
take both of the charges
wouldn't take
off if
I don't think they would divert one without diverting them both. I think it would
okay,
take them
so it
both.
would be both if I did that option? Okay.
Right, right. One
Okay.
diversion fee for both charges, but you'd still have to pay fines and costs for both.
Hmm. Okay. Okay.
Like I
So,
said, people think it's a great opportunity, others don't. It's just an individual preference after you look it over and see what they require.
yeah, so I guess I'll just have to wait and decide if I want, again, just the frivolous nature of the second charge is my issue here today. It's the failure to yield to an emergency vehicle and the conduct of the officer involved. So you're saying
Okay.
I would need to wait on that, or can we handle that
Well,
today?
I'm setting it for trial on December 10th, 2025, and the state's going to subpoena witnesses, including Trooper Elwood Phelps, who issued the citation. You'll need to have any witnesses if there are any that you want to call and any evidence that you want to present at that time. And I'm going to just carry the speeding. You may agree that you were speeding 91 in a 75, you may not, but I'm going to carry it over. Now, if the day of trial, you say, I really don't contest that, then I probably won't make them present evidence on it. I'll probably accept your plea if that's what you want to do.
Can
But
you
they
repeat
may
that? Can you repeat the last part? I'm sorry.
Okay, if you come back here and you say, I really don't contest the speeding 91 and a 75, they won't, I'll probably accept your plea of guilty, find you guilty, and they won't have to present their evidence on that, although they might bring it in, such as why they made the stop initially and so forth.
Yeah.
But that we'll address that at your hearing. And you do have the right to hire an attorney and bring your attorney in if you wish, or to at least discuss it with an attorney. But I can't appoint an attorney because there's no threat of jail time over you.
Yeah, so again, the pre-trial diversion, if I want to wipe away both potentially, that would be the option to do it, and then I wouldn't have to deal with the rest. Okay. And
Yes,
then
yes,
um
you could get them both diverted where you wouldn't even have to come back to trial. That's right, if you get it done before trial.
okay. I think I almost have all the questions answered. And then I'm curious though, does the county require is it a requirement for law enforcement to wear cameras? Would he have camera footage of the events that unfolded?
He may or may not. I don't, he's actually with the Kansas Highway Patrol. I don't know what their requirements are administratively. A lot of it, I don't know of any state law that says they have to. Some of them do because they can, some agencies do because they can afford it, some agencies don't. But I'm really getting outside of my bailiwick as a judge and getting into that of
Yeah,
an attorney. And so I'd
Yeah.
really request you ask those of an attorney.
sure. Okay, yeah, I just didn't know before I move forward, like, I think it'd be pretty cut and dry if they're required to wear body cam footage because that officer really shouldn't be conducting
Your Honor, is the court trying the case this morning?
Mr. Regier, of course it's not, but I'm trying to let Mr. Ballou have his first appearance and try to deal with as much of it as we can. But I understand, Mr. Regier, we have a full docket. There is a time and a place for trial, so.
Last question. If I choose to do the diversion, but I still want to have some recourse against this officer and his conduct, is that an option too?
I don't know what that would be, sir. I know if you asked me about a lawyer, I could tell you, a judge, I could tell you, but I can't with an officer. Probably someone in his administration. I don't know.
Yeah. Okay. I think I've got everything I need at this point.
Okay, and I hope everyone was listening because he asked a lot of good questions that could benefit, the answers could benefit others as well. So thank you, Mr. Ballou.
Thank you.
You're welcome. Mr. Regier, anything further from the state?
No, Your Honor.
All right, then Mr. Ballou is excused and we'll be in recess on his case. I am going to take just a moment to take up Mr. Standifer before I lose him here. Looks like he might be getting drowsy. We'll be on the record in BU 2025 TR 1747, State of Kansas versus William Dean Standifer II. Jared Regier for the state, William Dean Standifer II. That's you, sir. Turn on you're muted. If you click on your, thank you. Is that you?
Yes, Your Honor. Sorry about that.
All right, sir, you're charged in count 1, driving while suspended. Class B misdemeanor. If convicted, your penalty could be up to $1,000 and up to 6 months in the county jail. Count 2, you're charged with operating a vehicle without proper registration or expired tag, an unclassified misdemeanor. Your penalties could be up to a $2,500 fine and 30 days to 6 months in jail. Count 2, you're charged with displaying a license plate that was not assigned to your vehicle. An unclassified misdemeanor carries another possible penalty of 30 days to 6 months in jail and another possible fine up to $1,000. Do you intend to hire an attorney, sir, apply for court appointed, or waive and represent yourself?
Your Honor, I'd like to see if I would qualify for court appointed. If not, I'll hire one.
All right, are you employed?
Yes, ma'am.
Where do you work?
Ardent Mills, ARDENT Mills.
Ardent Mills. And what do they pay you per month?
You want me to give you that before child support's taken out?
Yes.
Okay, it's about $850 a week. 900 a week. 900 a week.
900 a week, so about 36 a month. And I know that there's more than 4 months. It's 4 point something
Right.
weeks in a month, but 3,600. And are you married or single?
I'm single, ma'am.
How many children do you support legally?
3.
And you said they take out child support. How much is that?
$416 a week.
How much per month? About 60.
About 1650.
Mhm. Do you pay rent or a mortgage?
Yeah, it's 1400.
You pay utilities?
No, it's all included.
Okay. You have
And
an
I-
automobile? Do you have an
Yeah.
automobile?
Yeah, it's no car payment, but I do pay insurance on it.
How much you pay on insurance?
$120 a month.
You pay, did you, oh no, you told me utilities are included.
Yeah, and cell phone's about $50.
Okay. Any other expenses?
No, that's pretty much it.
All right. I'm going to appoint Attorney Darren Patterson. His office is across the street from the courthouse. You're not there, so call him today at 316-32 822-7700. That is an order to call him today. Give him all your contact information. And the court date is going to be when, Destiny?
Your Honor, may I interject very briefly?
Yes, Mr. Regier.
Your Honor, this is a defendant who the state understands has a total of 3 Butler County cases currently pending. It does appear that the other 2 cases have court hearings separately in December. Based off the state's information, I'm not sure if the court wishes to take that into account at this time. It would appear that in one of the cases, a bond has been executed, and in the other, there has been personal service on a summons.
What's the personal summons date? Is it the same as his next court date?
Your Honor, it would appear that there was personal service on a summons in Butler County District Court case number 25 TR 2018. The date on the summons on that case appears to be December 3rd, 2025 at 9 a.m. before this court. In 25 TR 1257, there appears to be a hearing set on that matter on December 10th.
How about if we can consolidate all of those to Destiny? Do you have any one of those 3 dates that look really more open than the others?
Let me look. What was the first case number, Mr. Regier? I got the 25 TR 1257, but not the first one.
Your Honor, as previously indicated, the summons in the 25 TR 2018 case appears to refer to the December 3rd date. Also, I'm not sure if the court wishes to go on the record in all 3 of these cases for purposes of first appearance in the interest of judicial economy.
Oh, we haven't had first appearance in any of them?
That is the state's information, Your Honor.
Deputy Caulfield, did you have something to contribute?
That 3rd and 10th date are both on Wednesdays, Judge.
All right. Well, while you're looking at dates, Destiny, for judicial economy, I'm going to go ahead and take up, if I can find them fairly easily. Well, his name is familiar to me, Mr. Regier, on something he's been here on. Is that the 1257 maybe?
That is the state's information, Your Honor. It would appear there was a failure to appear back in August.
CBU. I'm not hearing you take any issue with what Mr. Regier is saying, Mr. Standifer. Are you in agreement?
No, the dates are correct, and yes, I did miss that court date, and took care of it with a bond and everything, and don't have any objections to anything Mr. Regier is saying.
So you have not been to court on these cases that he mentioned today?
That is correct, yes.
All right, we're going to be on the record in BU 2025 TR 2018, State of Kansas versus William Dean Standifer II, Jared Regier for the state, Mr. Standifer in person and pro se. In this case, sir, you have 1 count of driving while suspended, second or subsequent conviction. This is a Class A misdemeanor. If convicted, you could serve up to 12 months in the county jail and pay a fine up to $2,500. With the number of these you have, you could be looking at some must-serve jail time. Will be in recess. Okay, that one he needs a bond in or he doesn't, right?
Your Honor, it would appear that the court has already made issue. There has been a bond previously executed in the 1257 case. The state is not aware of any bonds having been executed in the 2018 case or the 1747 case.
All right, in the 2018, I'm going to set a bond for 2,500 OR since he's here voluntarily today on his summons. And then I'll look up the BU. And that's a 2025 also, right? TR 2025 TR 1257. Okay, this is BU, we're on the record in BU 2025 TR 1257, State of Kansas versus William Dean Standifer II, Jared Regier for the state, defendant in person and pro se. Mr. Standifer had a first appearance August 20th, 25, but failed to appear. So the matter was set for first appearance on October 22nd. That date will be modified herein. Bond was set at 3,000 cash or surety. That will remain the order. Well, he's here now. I'm going to make that OR.
Your Honor,
Mr. Regier.
with all due respect, the state would object to any modification. There has already been one prior bond in this case. Additionally, if the court is prepared to consider all three cases in the aggregate, the alleged occurrence dates are all three within 3 months of each other, approximately. So the state does maintain its position that the bond in the 1257 case is appropriately ordered by the court at this time.
All right, I'll leave that one at 3,000 cash or surety required, but he will need to turn himself in on that one.
And Your Honor, the state's information is that the bond has already been executed for a date in December.
All right, let me look at that. Well, I'm seeing the warrant. I'm not seeing the return just yet. He started out with a citation and notice to appear issued on the road by the officer. Then there was an amended complaint filed. Warrant issued. Return of service on a bench warrant. Okay, that's what I'm looking for. Okay, it was served, but where I still don't see where the bond has been served or filed. Well, that's the order. If he's already posted it, great. If he hasn't, he'll need to. Now then.
He should have been arrested on it.
Okay, he probably was. I just don't have the bond yet.
Your Honor, there appears to be such a document filed with the court in September in this matter.
I'm not seeing anything past July 16th, other than the October 22nd court date, which had to be set somehow. It says it was set per ticket. So we may have to sort through this file, Destiny, and figure out why they have something different than we do. Basically, what I need is a bond posted.
We just need the bond in the 25 TR 1257, though, right? Correct, Your Honor?
Oh, okay. I'm looking at BU 2025 TR 1747.
Your Honor, the state understands that 25 TR 1747 was the case previously set on the docket today. The state is not aware of any prior court appearances in this matter.
All right. So what's
many
the case?
bonded on
What's the third case that he hadn't appeared on? Or
Your Honor, the case on the docket today from the state's information is 25 TR 1747.
right?
In 25 TR 2018, that is the case where there was previously personal service on a summons for a date in December.
All right.
In 25 TR 1257, their state understands there was previously a failure to appear in August and a bond was executed for a date in December.
All right. So I've addressed his charges let's see. Which one do I still need to address, Mr. Regier?
Your Honor, it would appear that there hasn't been a first appearance in either of these cases, but for today, the state understands the court had previously addressed the charges in 25 TR 1747 on the record today.
Well, I just went over one of those other two that you gave me. We had one driving while suspended.
And that would appear to be in accordance with the information filed with the court in 25 TR 2018, Your Honor.
Okay, so I've addressed 1747 and 2018, and the remaining one is what?
25 TR 1257 by the state's information, Your Honor.
All right, let me look at 1257.
And Your Honor, I did just want to make sure that we were on the record in all three. We've added them to the docket today.
I'm trying to as I have them. Yes. BUTR. I think I addressed that last one on the record, but we'll clarify to make sure. BU. Mr. Standifer, you have too many cases before this court that
Yes,
are
ma'am.
causing a fair amount of confusion because so be you. 2025 TR 1257. All right, we are on the record in BU 2025 TR 1257. State of Kansas versus William Dean Standifer II. And sir, in that you are charged with count 1, driving a vehicle without registration with expired tag on June 1st of 2025. That is an unclassified misdemeanor. The penalty could be up to $2,500 in fines and 30 days to 6 months in jail. In count 2, you're accused of driving without proof of insurance, a B misdemeanor, $300 to $1,000 in fines and up to 6 months in jail. Now, if you have a prior to that, this becomes an A misdemeanor. The penalty could be up to 1 year in the county jail, and the fine could be from $1,000 to $2,500. In count 3, driving while suspended, second or subsequent conviction, the subsequent elevates this from a B to an A misdemeanor, and the penalties could be up to $2,500 in fines and up to a year in the county jail. Count 4, failing to wear your seatbelt is an infraction. It carries a fine of $30 or $60, one or the other, but no jail time. I think it's a $30 fine. Now, that's on the record in 2025 TR 1257. And are you hiring or applying for an attorney?
Are you still able to get me Darren Patterson, or do I need to acquire my own?
Are you, well, you qualified for, and I appointed Darren Patterson in the previous cases. That's still your financial situation. It hadn't had changed in the last 5 to 10 minutes, has it?
It is not, Your Honor.
All right, I'll appoint Darren Patterson in all of these 3 cases, the 2025 TR 1257, 2025 TR 2018. Still on the record in all cases. So much for judicial economy today. All right, in the 2025 TR 218, State versus William Dean Standifer II, still on the record, 1 count of driving while suspended, second or subsequent, an A misdemeanor, penalties up to $2,500 in fines and 1 year in the county jail. Darren Patterson appointed. Court date to be determined shortly. And then that brings us back to the case that we were supposed to be here on today alone. That is BU 2025 TR 1747, State of Kansas versus William Dean Standifer II. Driving while suspended. If there is a prior, this becomes another A misdemeanor, punishable again by up to $2,500 in fines and 1 year in county jail. Count 2, driving without registration or expired tag, an unclassified misdemeanor, penalties up to $2,500 and sentence 30 days to 6 months. And count 3, driving with a license plate displayed that is not assigned to the vehicle, another unclassified misdemeanor, penalties again up to $2,500 and sentence possibly 30 days to 6 months. Darren Patterson assigned to all 3 of these cases. And deputies, which ones do you not show that he's been processed in?
This, the one that was on today, 25 TR 1747, for sure he needs processed on.
All right, I'm going to order that he be processed on it and any others of the 3 that he has not processed. You can check the jail records and determine that.
And Your Honor, the
Mr.
safe information is that if the court is ordering a $2,500 own recognizance bond in 25 TR 2018, count one appears to be charged as a Class A misdemeanor. So it would appear that statute provisions concerning booking apply in that case as well.
All right. And do you have a recommendation on any of these cases concerning processing, Mr. Regier?
Your Honor, the state is recommending that the defendant be ordered to report for booking as required by law in 25 TR 1747 and 25 TR 2018.
Recommendations on bond.
Your Honor, the state understands that the court had previously ordered a $2,500 own recognizance bond on the record in 25 TR 2018. If the court is maintaining its orders, the state has no objection to the court ordering the same in the 25 TR 1747 case, given the nature of these cases, as well as the respective alleged occurrence dates, as a special condition of bond in all three cases.
Just a moment, Mr. Regier. Deputy Goffeld, could you mute, please? Could you mute? Thank you, sir. Go ahead, Mr. Regier. You were saying 1747?
Yes, Your Honor. The state is not opposed to the court ordering a $2,500 own recognizance bond. By the state's count, that would come up to an approximate aggregate of $8,000, either own recognizance or cash or surety or professional surety across the three cases. The state is recommending as a special condition of bond in all three cases that the defendant report for pretrial court services monitoring, and I will defer to the court as to any appropriate court dates if the court is prepared to set all these cases on the same docket.
All right. Destiny, what date were you going to set for the one that we were scheduled on today, the 1747, I believe it is?
Yes, I can schedule all three, Your Honor, on December 29th if we're appointing Darren Patterson in all three cases.
December 29th, 8 a.m. All right. Mr. Standifer, make sure you get this date right.
Yes, ma'am.
I'm moving all three of your cases to December 29th, 2025. You're to be at the courthouse at 8 a.m.
Okay.
Do not be late.
I'm writing it down. Yes, ma'am.
Call Darren Patterson. Okay, call Darren Patterson's office as soon as you're through talking to me and talking to these officers. When I'm through with you, you're going to go into a breakout room with his court security too.
Okay.
And you're going to set up a time to make sure that all your booking and processing is done and all your bonds are signed. The OR means you don't have to put up any more money unless you fail to come to court. And then you're going to have a judgment by the state of Kansas for that aggregate amount of $8,000 something Mr. Regier referred to.
Yes, Your Honor.
And you're going to have 3 warrants out for your arrest. So make sure you don't keep burying yourself with this driving. I know you've got to get to work. I know you have things to do just like everybody else, but you've got yourself in a situation where you cannot afford to be out there driving for any purpose. You know, you probably, the officers probably know you and your car by now just by seeing you up and down the road.
Yeah, it's my license has been reinstated, but that's not the point of what you're telling me, and I do understand that, ma'am.
I'm glad to hear it's reinstated, but make sure your cars have tags and insurance. They have the right display plates, etc.
I'm good now, but regardless, I will be there and I'll take care of this.
All right, and do call Darren Patterson. You probably have his number.
Yes, ma'am.
You call him again today when you're through talking to all of us. Tell
Okay.
him what you have going on. December 29th, 8 a.m. Don't miss that date.
Yes, ma'am.
Anything else, Mr. Regier?
Your Honor, the state's oral motion to add pretrial court services monitoring as a condition of bond in all three of these cases.
Well, that's certainly a reasonable recommendation, but I'm not going to bury them with 3 more cases when you can just take care of this yourself, Mr. Standifer. You're a grown man. You can do this yourself.
Yes, ma'am. I will.
But I understand and appreciate your concern, Mr. Regier. It makes a lot of sense.
Thank you, Your Honor.
You're welcome. All right. Now, Deputy Caulfield.
Just one question. On the 2 cases that we're going to process him on, that's $2,500 OR on each case, correct?
On 1747 and 2018, yes.
Okay, thank you.
You're welcome. All right. Now, Destin, if you'll put Jared Regier and not Jared Regier, put William Standifer and court security 2 in a breakout room, please. If you see that, click on it. There we go. All right. So much, as I said, for judicial economy. We just buried our docket today, didn't we? But it'll help hopefully in the future. All
Your
right.
Honor, can I interrupt, please?
Scott Lamb, yes, sir.
I got
Okay,
one
I'm
more.
sorry. Okay, I just want to ask if I can be seen. I have a broken rib and I can't sit here anymore. I took my pain pill. I'm falling asleep on it.
All right,
I'm not,
Deputy. I'll fit you in here, Deputy, and we're going to be on the record now in BU 2025 TR 1777, State of Kansas versus Scott Francis Lamb, Jared Regier for the state, Defendant Lamb appearing in person, and pro se, having just told the court that
hold on, Jess.
he has. What was your condition, Mr. Lamb?
I have a workman's comp case and I have a broken rib and I have a doctor's appointment here in 45 minutes and I just took 2 of my pain pills. So I'm not going to be very good here in about 10 minutes.
Well, I hope you've got someone to drive you to the doctor's appointment.
Oh,
Then.
absolutely. My wife is, yes.
All
I
right,
can't
well,
drive.
sir, let's get this done then. Sir, you're here on first appearance. Count 1 alleges speeding 87 in a 70, a traffic infraction. If convicted, there is a scheduled fine, but no jail time. Count
Yes,
2,
ma'am.
you're charged with driving without an ignition interlock device as required as a restriction after being convicted of a DUI. So driving a vehicle without ignition interlock when you should have had one is a Class A misdemeanor, as you may have heard in the case before you. The penalty could be
Yes.
up to $2,500 fine and a year in the county jail. Sir, are you going to hire an attorney, apply for court appointed, or waive attorney and represent yourself?
I'd like to plead guilty to the speeding ticket, but on the Intoxilock, I've been done with it for over a year and I have letters from
All right.
DMV, so I would like to have a legal aid. I'm on workman's comp and I have not got a paycheck so far in 8 weeks, and I just got a lawyer hired yesterday. My company has not been paying me whatsoever. So I'd ask that I will plead guilty to the speeding ticket if you could give me the
Hold
120
up.
days or
Hold up.
sorry, ma'am.
All right. So
Sorry.
you're on.
Uh,
Hang on. You're on workers' comp disability because you've been injured in the line of work, and you said you said, I thought I understood you to say workers' comp, but you're not getting paid?
Well, I was approved for the first 3 weeks and then I got denied. So I have not received one check so far in 7 weeks. I had a lawyer, I hired a lawyer yesterday who was taking care of the case. So right now I'm living on my wife's income that only works on commission. And we don't have enough money to pay the bills as it is. So I would ask that on the Intoxilock that you could
All right.
present me with a
I'm
legally.
going to stop, sir. I'm going to appoint Attorney Darren Patterson. His number is 316-322-7700. I'm ordering that you call him today. Give him
Yes,
all of
ma'am.
your contact information. I'm ordering that you reappear. What day does he come back, Destiny?
Your Honor, we now have January 5th at 8 a.m.
You
That'll
must be
work
back
great.
January 5th, 2026. Be here at 8 a.m. or whenever Mr. Patterson tells you otherwise.
Okay. I did have one other question for you. I'd like to do the diversion. I've been trying to write down, as you've been telling everybody, I have BU, but I'm sorry, I can't comprehend
Well,
it. If
all right. Well,
I would like to.
Mr. Patterson's probably going to want to walk you through that himself. So talk to Mr. Patterson about that before you apply. If you just want to read about it before you talk to Mr. Patterson, it's BU, the first 2 letters of Butler,
Okay.
and then
BU.
BU, B Butler, BU, and then CO, the first 2 letters of county,
Okay.
and then KS for the postal abbreviation for Kansas.
Yes, ma'am.
So 6 letters, BUCOKS.
Yes, ma'am.
You have that, and then
Yes.
.gov, G-O-V.
Okay. That would be great. All right. And
Okay,
that's all I need.
but I would
And
suggest
I
you talk to Mr. Patterson before you do anything else on that besides just read up on it.
yeah, I will call him right now. I appreciate it, and I'm sorry for interrupting the court. Like I said, I'm
No,
just
I
in
understand you have a
extreme pain.
need now. Before you go any
Yes.
further, though, Do you
Yes,
need to
ma'am.
process him, deputy?
Yes.
All right, I'm gonna set, Mr. Regier, do you want to be heard on bond for this?
One moment, Your Honor.
Okay,
Thank you.
you're welcome.
Your Honor, may I go off mic and off camera for 30 seconds?
30 seconds, yes, as long as Mr. Lamb can hang in there. Thank
Thank
you.
you.
Absolutely. No problem.
All right, thank you.
Thank you, Your Honor.
Back on the record, all parties as before in State versus Lamb. Go ahead, Mr. Regier.
Your Honor, the state has no objection to an owner recognizance bond given that the defendant appears in the fashion that he does today. The state would be recommending at least a $3,000 owner recognizance bond in this matter. Besides the nature of count 2 currently before the court, the state understands this is a defendant with at least one prior failure to appear, one prior conviction for no proof of insurance, and at least 2 convictions for non-traffic related felonies.
All right, Mr. Lamb, your bond is set at 3,000 OR. Please click on the invitation to a breakout room with court security 2, and Destin, if you'd please put court security 2 and Scott Lamb in a breakout room.
Okay, just one question. So I'm gonna be put on bond for this case?
Yes, but you're not gonna have to put any money up unless you fail to come to court.
Okay. Yes, ma'am.
It's-
Okay, I appreciate it. Thank you, sir. I do appreciate it.
Chowdhury? Nazir Chowdhury? Nazir A. Chowdhury, 25B82624A, B, and C. Your name, sir?
It's me, Greg Gonzalez.
No.
Chowdhury for Nazir Chowdhury.
All right, good morning.
Good morning.
What's your name?
My name is Jawad Chowdhury.
Yeah, okay. Now, you said your father can barely speak, you told me last time, right?
Yes, that's correct.
Did you guys talk to the building department over there?
Yes, I have removed all the dirt. The only problem is I cannot do the front of the driveway is because I got let go from my job like a couple days after the last court date. So I don't have the funds to be able to do the repair. I'm applying for different jobs.
Second, sir. Hang on.
Sorry.
Oh, Caitlin.
Can I have you come in here on this Chowdhury case, please?
Yes, sir.
Yeah, I can't put this off forever. You
Right.
follow me?
Yes.
I can't do it. I mean, I can't do it. This is, the citation was issued September 2nd. There's not been an arraignment. And I cannot let you represent your father. I thought we were going to get your father a lawyer. Lisa, did we set up the defendant with an attorney on this? I'd written
No.
down. All right, so I said adjourn 2 weeks, set defendant up with attorney. I need him to have an attorney.
Well, the defendant didn't appear, so
Yeah, I know. Well, the defendant can't appear, it sounds like. Your name?
fully clear. President Township.
Your name?
Rob Harris on behalf of Brown South.
Did you go out and look at this property? Tell me it's in good shape or it's at least getting better.
All I did is move everything to the back there.
You can't do this stuff. Listen to me.
I tried to put it in a storage.
Hang on.
but-
Hang on.
Yeah, photos taken from when the citation was issued and from yesterday, if you'd like to see them.
I need your father to appear on this. He is responsible for this. I'm sorry that he's ill, right?
Yes.
I'm sorry that he's ill. What are these bags of?
Been soil around.
Why didn't you get the garden soil out of here? What is going on? They still sitting there?
They're now in the backyard, which isn't any better than one.
I plan on moving them to a storage facility, but the
Mr.
thing is,
Chowdhury,
I got fired.
Mr.
so-
Chowdhury,
Yes.
who wants to look at this junk? Who wants to look at this junk? I can't believe this junk was sitting across the front yard and on the driveway like this. I mean, I don't know. Maybe if you didn't live anywhere within 10 miles of your neighbor, looks like there's houses right next to you, behind you, everything else. Who wants to look at this junk? I'm not going to play games on this. I'm telling you, I'm not going to play games on this. What else is the problem besides these bags?
There was a fence installed without a permit. And there are weeds and other.
The driveway,
I can see there's all kinds of weeds in the driveway.
well, the driveway's unsafe, that needs to be.
Well, repaved. Yeah, you can see that unless somebody wants to break their legs. Mr. Chowdhury,
Yes.
you're going to force me to get tough. I don't want to get tough.
I'm not. I'm not trying to.
Mr. Chowdhury, Mr. Chowdhury,
Yes.
I want you to understand me very clearly here. This is going to get done. The only
Okay.
question is how painful is it going to be for your father and or the rest of your family if you do it as at your pace as opposed to mine? Okay? You have to apply for permits when you erect fences. You can't have junk all over. This driveway looks like a bomb shelter. I mean, it looks like it's been bombed, I should say. Not a bomb shelter. I don't know what to do short of requiring his father to come into court. How old's your father?
80 something. 80 something.
Well, that's not too old. I mean, what kind of an illness? Why can't he come to court is my question. Because that's
Diabetes, health issues. He can't stay awake.
Well,
he's
you're
got
going to have
heart-
to bring him to court next time, okay? If you want to make this painful, I can make it painful. I don't want to make it painful.
I'm not trying to make it painful. I
Well,
just
you
lost
need
my
to do
job.
what I told you to do. Listen,
Okay.
I'm adjourning this 2 weeks. Your father's coming in person. If I get a note from a doctor telling me it's unsafe medically for him to do that, then I will reconsider my decision, and I will obviously not do that. Lisa, give me a time in 2 weeks. I want him to have a lawyer, appoint him a lawyer. There has been even no arraignment yet because Mr. Chowdhury here, Jawad, has been showing up. I believe I had his father on camera. So what is that, the 5th?
November 5th at 10.
Take your pictures back, please. I want everything taken care of. You're gonna have to apply for the permit. You're gonna have to get a
Okay.
hold of the building department. We're gonna have a lawyer for you. You're gonna have to bring the father, defendant to appear in person.
Okay.
Don't make this hard.
I'm not trying to.
Well, you kind of are. You kind of are. You guys start erecting things without permits. You move the bags just to the back. You got a driveway there that it's more of a hazard than anything is what I'm worried about. I'm surprised the mailmen haven't fallen down and broken their necks. We'll see you back here. I expect him to be here. Do we understand one another?
Yes.
Lisa, that's to be in person, all over that. Thank you. I don't know what else to do on that one. I'm sure Mr. Boyd here is not going to be an easy one either. I'll call you when that case is ready. Thank you. Istilart. David Istilart Gonzalez, 25W836-565. Mr. Istilart? Your name, sir? You have to start your video and state your name.
David Istilart.
All right. So I've got a charge, and it was fair to attend the court work program on September 27 of 25. I adjourned it and said you could appear by Zoom. Again, I'm going to offer you the right to a lawyer if you want one. Would you like an attorney?
No.
Do you wish to have a hearing, or do you intend to plead guilty on this?
Hearing.
Okay, let's get in Ms. Tassino in here, John, real quick, and we will have that hearing. Okay, the charge, again, you understand, is fair to attend the court work program on September 27, 25, correct?
Yes.
All right, and you know that I entered a not guilty plea for purposes of arraignment, correct?
Yes.
Ms. Tassino, your name?
Emily Casino.
He pled not guilty at the initial hearing. I don't remember why I adjourned it. I think you might have been out.
Here, I just didn't get in for quick enough.
Well, we're prepared to go with the hearing. Are you ready to testify?
Yeah.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
Yes.
All right, go ahead.
I have the report right here for the court work program dated September 27th of 25. He was a no-show. There is a note that he showed up at 8:55 a.m. But because he was late, they locked the doors at 8:35. He was not permitted to work. Therefore, he wasn't able to complete the court work program day.
Do you have any questions of her? Mr. Istilart?
No.
Yeah, do you wish to testify or remain silent?
Testify.
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole true self you got.
I agree. Yes.
You do?
Yes.
Okay, go ahead. Tell me what you'd like to say.
There was a car accident which was completely out of my control, and I had to circle around trying to get there. I know it's just a 5-minute thing, but I did show up there.
Where was the accident?
I think it was around before 4th Street, and I'm not from the area.
4th Street? What's 4th Street in Trenton?
No, not Trenton. I don't remember the name of the street, to be honest.
Well, why were you 25 minutes late? That's a long time.
No, I don't know why it says that. I arrived at 8:40.
Who wrote 8:55?
Yeah, I don't know what supervisor was working that day, but he said he showed up late around 8:55.
All right.
He was notified that he could not work today.
No, and he even told me we're on camera. So I'm pretty sure I checked my watch. It was 8:40.
I'm going to find you guilty as charged of failing to attend the court work program. You have to get there on time. I will have you do anything else you'd like to say? That's your first technical violation. Anything else?
No.
Pay additional costs of $100. Serve an additional day on the court work program. So you're going to have an additional day to be on the court work program. You want to talk to him and pay $35 for that. So you owe $135.
I'll send an email.
All right, she's going to email you. You owe $135. Can you pay that today?
No.
When can you pay that?
Can it just be added to the tab?
He's got a payment plan.
$100 weekly?
I have expenses.
Yes.
Lisa, just add these fines costs in system, and he can pay at the same rate, okay? All right, that's what I'll do, Mr. Istilart. So she's going to email you and schedule your court work program. Did you say something, Lisa?
Yeah, just so you know, he's not up to date on the payment plan. He's making $1 payments, it looks like.
$1 payments.
He paid $100 on September 15th, and then we received $1, another $1.
What? $1? You paid $1 on October 14th?
No, I paid 100.
When did he pay his first 100?
September 15th.
And they paid 50 on October 7th, right?
Yeah, and then $1 on the 14th.
Why would you pay $1?
Then I got $1 again on the 21st.
Why would you pay $1?
No, I just click and pay the $100.
We'll check your bank account, sir. Maybe you can see what happened.
You're saying you made two $1 payments.
Yeah, I have a $1 payment on October 21st and a $1 payment on October 14th.
I have the payments on the screen, Judge.
That's what it says. Restitution on your credit card. Why would you pay $1? Tell me why you would pay $1. I just want to know why somebody would go on a credit card and pay $1.
No, I need to check on that, but I clicked and I'm pretty sure it said 100. I don't know why it said $1. I don't know if there's a hold on the credit card or something.
A hold on the credit card? What do you mean?
Like a pending charge or something before it releases the money. I don't know how that works. But I paid $100 online.
Well, you better provide us with proof quickly. So I would check that now. Are you working?
Yeah.
What time? Today?
Since 7 a.m.
You're at work now?
Yeah. Well, I mean, I requested time off. I work from home. Sometimes I go to the office.
Well, you better check it. Okay?
Okay.
I mean, we don't make mistakes like that. That was October 14th and 21st. I mean, I'm not really amused if somebody's doing it on purpose. I mean, I guess I got to have a better sense of humor. But I can't imagine somebody paying $1. So you provide us with proof that you paid 100 and we'll adjust. But we don't make mistakes like that. All right? So you better take care of that real quick or you're gonna have another show cause pending.
Okay.
Good luck.
Thank you.
All right. Robert Thomas Boyd, 25BA 2557. All right. Calling the prosecutor. How you doing, Mr. Boyd?
Hi, sir. How are you?
Not too bad. Your name?
Robert Thomas Boyd.
Are they going to give me good news when I call them out and they're going to tell me that you've done what I asked you to do? Or are they going to tell me that you haven't done it all of what I asked you to do?
I've got a big dump by the garage. I'm ready to go.
Ready to go. What do you mean?
Get my permit today or tomorrow.
Mr. Boyd, you're not going to make me put you in jail again, are you?
I hope not.
Well,
I
come
can't get
on.
it done from there.
Mr. Boyd, I can't wait to hear what they're going to tell me. I've been waiting for bated breath since my recorder told me you were coming in here today. Yesterday, she told me that, oh boy, what has Mr. Boyd done? Or more importantly, what has he not done? Has he done anything? All right. I'll give you a lawyer if you want one. If you want a lawyer, I'm going to give you one right now. Do you want a lawyer?
No, thank you.
Your name.
Caitlin Fuller, Clarendon, Brunswick Township.
Your name.
Dr. Someday up, prompt up.
What are you going to tell me? Tell me it's all cleaned up. Tell me it looks like the Taj Mahal. Tell me we'd all want to move in there.
The only progress is that he's gotten a dumpster this week delivered to the site. Not the side of the dumpster that I commit that the garage is still.
Oh, Mr. Boyd, you're killing me. You're killing me.
I was waiting till I come in today before putting anything in the dumpster. But
Why?
if you send me to jail for 85 days, I'm gonna send the dumpster back. I can't have it sit there.
Why are you being a wise guy with me?
I'm not, sir. I'm just telling you the truth.
I don't know what to do with it. Short of sending him for 85 days. He's gonna be in there for Christmas. How old are you again?
Pardon?
How old are you again?
78. The 27th of this month.
Well, we share a birthday. Just, you have a couple years on.
Yes, sir.
What am I gonna do?
Your Honor, I don't know what to do. We did have an opportunity this morning to speak to Mr. Boyd. He told us just about the same, that he hasn't done a whole lot since the last time we were here. He hasn't obtained a demolition permit to take down that garage, so
He has or hasn't?
so he's made no progress towards doing at least that very first goal. I do have a picture that Mr. Harris took yesterday showing the front of the property that still has the trailer, the boat, the vehicles, what have you.
I don't know why you're making me do this. I don't know why you're making me do this, Mr. Boyd.
I put the boat out in front.
Mr. Boyd, I don't know why you're making me do this. I do not know why you are pushing me to the point that you leave me no choice. I don't understand why you're doing this. I really don't understand it.
I do work slow. I'm 78, you know.
You haven't done anything.
I have. I've done a lot. I've moved a lot of stuff. I had to throw away what I didn't want.
What did you move? What did you move? When did you move it? I don't know that you've done anything.
You wouldn't see it because I put it away.
Can you guys give me something positive here?
Try to start with the positive that he got the dumpster. He has not pulled, nothing that the boat says it's for sale, there's not a for sale sign on it. I mean, at least put a for sale sign on it if you're gonna park it in front of yours. Cause he's moved the boat when you were there, it was in the back.
Right.
He moved it to the street.
Nice.
Makes it look worse, but he says it's for sale, but there's not even a for sale sign on it.
How's somebody supposed to be a mind reader? See a boat out there and they think it's for sale without a sign? Don't have anything to be for sale if there's not a for sale sign.
My son promised me that he was gonna put a sign on it. He's half owner in the boat.
I don't know what to do. Do you have any ordinance that allows you guys to go in there and clean it up and put it on his tax rolls?
Short of abating the nuisance civil court, we don't have that.
Short of a what?
Abate the nuisance civil.
In circuit court. I know, but maybe that's the route you need to go.
I was hopeful that this would have put Mr. Boyd on notice, and I understand that doing some time maybe would have jump-started the progress, but unfortunately.
I don't know what,
Give me a chance to start tearing it down.
I don't know, Mr. Boyd.
Got a
Come on.
nice big dump box here.
How long's it been going on, this case, Miss Foley Carter?
Based on the register of actions, he's had ordinance violations dating back to 2011.
2011, we were young then. You were young, I was young.
This citation was issued back.
It's 14 years ago. Go ahead, I'm sorry.
Sorry, Judge. This citation was issued back in April. Prior to that, he had the civil infraction citation for the same thing.
So you've done nothing. You've done nothing. When were you last in court? Mr. Boyd, I feel horrible. You are a pleasant, likable man, but you are not complying with orders. That's a dangerous building.
Yes, sir.
Forget the blight. It's just flat out dangerous over there. And I can't get you to do anything. I usually would like to think I'm more successful at causing people to understand that they have to do something, and I don't know what to do with you. I really don't. I don't know what I can do. When were you last here? A month ago?
something like that.
And you've done nothing but move the boat out without a for sale sign and order a dumpster that has nothing in it.
My truck was in the shop for 3 weeks.
Well, good. Then if your truck was in the shop, then you had to be home and you had all kinds of time to do things. I don't know what else to do, guys. I just don't know what else to do. If I saw some effort.
Well, I'll see how well I do with the dump.
New review hearing date in 4 weeks, Lisa.
November 19th at 8:30.
November 19th at 8:30. When I go home tonight, I'm going to feel horrible. But I have to give you another 5 days. I'm setting another review hearing date on November 19th at 8:30.
That doesn't give me.
Mr. Boyd. It's just this the way it's going to go until you take care of the property. You think I feel good about this? I'm not going to argue with you.
Yeah.
I'm not going to argue with you. You're just defiant. I don't know what is going on with you, but I can't allow this to go on. I just can't. This is nothing I want to do. Zero interest in doing what I'm doing right now. None. I'll go home and think about this tonight. Like, what could I have said to Mr. Boyd on the multiple other occasions that he appeared in front of me that might have compelled him to do something?
I feel I have done things.
Mr. Boyd? I'm sorry. Have a seat. I feel horrible. You make me do things I don't want to do. Have a seat over there, sir. People against Scott Astin. People against Scott Astin, 258-255-82573. Your appearance, Mr. Wayne?
Good morning, Your Honor. Matthew Wayne on behalf of Seal Township.
Mr. Astin?
Scott Astin, defendant.
All right, so you referenced in your, Mr. Wayne, you referenced in your brief, your case brief here, and then defendant filed a reply brief. You referenced that you'd given me a packet information when you and I and Mr. Astin were in chambers, I believe, right?
Yes, Your Honor.
That was a few weeks ago, and I'm trying to figure out what it was that was. What did you hand me?
So there was a case in the Wayne County Circuit Court from approximately 5.5 years ago. Isaac Akana LLC,
And
was
that-
the defendant, then Seal Township as the plaintiff. It was before the Honorable Judge Gillis.
Okay, and you provided, I believe, as well, a copy of that to Mr. Astin, right?
Yes, if I remember correctly, copies were made with one of our staff.
Is that true? You received that?
Yes.
I just wanted to double check on that. How do I say this? You don't have to have a lawyer, Mr. Astin. They're charging you in your personal capacity with a civil infraction. You have the right to represent yourself on the most routine of civil matters or the most serious criminal matters if there was ever a time you were charged with something serious. I'm just suggesting to you that you may well want to get a lawyer. I mean, I read your brief, it's fine. I suspect you got it online from somebody or somebody ghost wrote it or it was an AI put together thing, but whatever it is, it's fine. But now you're in court and you have to verbally enunciate. And I'm sure that this probably means a lot to you. I mean, I don't know if you strictly had this home for an Airbnb business or not, Airbnb business. If that's what you use it for, the income that's generated, I don't know, but you might want to do that. If you want to do that, I'm going to give you an adjournment. If you don't want to do that, then we're going to have to proceed right now.
We can proceed, Your Honor.
You don't want to hire a lawyer.
On appeal, I believe it's a de novo review.
Okay. All right. How do you intend to proceed here?
Your Honor, so, you have the legal underpinnings of each party's position. Witnesses that the township intends to call today are the individuals who can testify to personal knowledge regarding the property, what they witnessed, their interactions, if any, with the property, and the notice that was given to the defendant regarding the issues with the property.
Okay. So you're going to call witnesses?
Yes, sir.
Yeah. All right. How many witnesses do you have?
2, Your Honor.
And do you wish to give an opening statement?
No, Your Honor.
Do you wish to give an opening statement, Mr. Astin?
Sure.
Okay.
Defining the facts is the crux of this litigation. Pursuant to the definition set forth in the Township of Roseville zoning ordinance, which both parties in this court are bound by, fact which is not in dispute is defendant lets and or leases a dwelling unit located in a single-family residential district on a temporary and or transient basis, which is a permitted principal use under the zoning ordinance. What the Township of Roseville is trying to do with this litigation is amend the zoning ordinance by judicial fiat. The current zoning ordinance does not place any restrictions on the amount of time a dwelling unit can be rented for. Should the township wish to regulate and or restrict the duration of a rental of a dwelling unit in its single-family residential districts, the proper procedure for amending the zoning ordinance is for the township to hold public hearings on the matter and amend the zoning ordinance if necessary after that public input. For the reasons stated herein, I urge this court not to legislate from the bench and find defendant not guilty of the zoning ordinance violation as asserted by the township and award costs to defendant.
Call your first witness.
Your Honor. Answer calls. Squirrel.
Yeah. John. Your name, sir?
Squirrel.
Raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Okay. Give me 1 second, counsel, all right? If you can find it. All right. Sir, spell your name for me.
First name Ross, Ross. Last name Quero, Querr.
Thank you. You may proceed, Mr. Wayne.
Thank you. Okay.
Good. How are you?
Fine, thanks. We know your name, what's your position?
Community Development and Downtown Development Director with Roseville Township.
And how long have you been an employee of Roseville Township?
A little over 3 years.
Okay. I'd like to take you back to on or about August 20th, 2025 in Roseville Township, County of Wayne, in the state of Michigan. Something happened that day to brought you here today?
Yes.
Okay. So tell me why you're here.
It's been routine since my 3 years with the township to actively pursue Virgo Airbnb listings in the island. And we came across this listing. It was pretty obvious that it was a violation of our ordinance as per Wayne County Circuit Court ruling.
Objection.
What's your objection?
It's not in violation of the township zoning ordinance.
Okay. Wait a minute. Stand up. Tell me what your evidentiary objection is. He said it was pretty obvious that it was not compliant with the zoning in accordance with the decision of the Wayne County Circuit Court. So I want to know what your legal objection is to that.
Defendant, myself, lets and or leases a dwelling unit located in a single-family residential district on a temporary or transient basis, which is a permitted principal
So
use.
what is your legal objection to his answer? You said you objected. I'm not sure what your objection is. You might disagree with what he's saying. I'm going to overrule your objection. Continue your answer.
That was the short of it.
Thank you.
So,
All right. And so again, just to reiterate here, so you said as part of your job, you're just going to focus the township on.
yeah, actively pursuing Verbo and Airbnb listings on the island.
Okay. And so for the address in question, you said we, so who would we be?
Me, myself, and zoning administrator, James Brock, and, our code enforcement officer, newly recorded, is kind of a team for.
So this is something you discussed with your colleagues.
Correct.
Okay. So we're talking about 27595 Alba in Grossfield Township, correct?
Correct.
Okay. So how did it come to your attention, that this, property was being offered as a short-term rental?
Yep, saw it on a Verbo, listing.
Objection. Short-term rental is not defined by statute. According to the Roseville Township zoning ordinance, chapter 285-24.5.
Is there any other legal objection that you have?
Carrying out the designated duties, an enforcement officer shall administer the chapter precisely as it is written and shall not make changes or vary the terms of the chapter. Short-term rentals has not been defined by ordinance or by the courts.
Can you define what you mean when you tell us short-term rentals?
Yep, short-term rental is, anything less than a month-to-month basis. So, our common practice has been, if you are, if you rent out a property from the landowner, you have a lease agreement, that's not a short-term rental. A short-term rental is anything less than 30 days at a time. It's been our practice.
Go ahead.
So, and you indicated that through Verbo and through Airbnb that the subject property was being as short-term rental in conformity with the definition you just provided.
Correct.
Okay. So what did you do at that point?
I scrolled down on the listing, saw the name, looked up the name. It was a resident on the island, sent the notification that they were in violation.
I'm sorry, I can stop there. So who's the resident we're talking about?
Max Astin.
I'm sorry?
Max Astin, or Scott Astin, I'm sorry.
Okay. Is that an individual here today?
Yes.
Please identify him for the court.
Record should so reflect the witnesses identified the defendant.
So through the Department of Community Development, correspondence was sent to the defendant.
Correct.
This is Township's proposed Exhibit 1.
Yes, you may.
Sorry.
You're gonna hand that one to the, let's have it marked before. You don't have that document in your hand marked yet, correct?
No, Your Honor.
Okay, so let's have it marked Peoples 1, and then you can approach the witness and show the witness if you'd like.
Take a second there just to review that.
Is that marked plaintiff's proposed exhibit or People's proposed exhibit number 1, sir?
Yes.
Okay, can you identify that?
Yes.
Tell us what it is.
It is a notice of violation of operating Airbnb dated May 5th, 2025.
Okay.
So there are 3 pages, correct?
Yes. And then on the second page is June 23rd, 2025, a letter from James Brock notifying the individual that they're in violation, and then a final one on July 29th, 2025.
Even though the correspondence, at least the second and third notices that you just referenced, even though they were issued in the name of James Brock, zoning administrator, have you seen these before?
Yes.
Okay. Are you familiar with the content?
Yes.
Okay. So the first notice that you have, what's that notice about? Take your time.
Yeah. It's just it's our general template notice of violation.
Okay. And it's letting who know what?
That they're in violation of the township municipal codes by operating an Airbnb.
Is there any amount of time to remedy the violation?
10 days.
Okay. Flipping to the second page, and that's dated when?
June 23rd, 2025.
Okay. What's the substance of that notice?
Basically providing the resident information about the case, the Wayne County Circuit case, providing that information that, residential property cannot operate as short-term rentals, and failure to discontinue the use of the property as a short-term rental would result in the township taking legal action against them.
Is it so? It's fair to say by the time that second correspondence would have been issued, that the remedy still wasn't, rather that there was no remedy to the violation at the time, correct?
Correct.
Okay. And then the third page, if you would.
It's basically essentially reiterating the same letter as before, but
What's the date on the third document?
July 20th.
July 29th.
Yes.
So by that time, is it fair to say that the violation still wasn't remedied?
Correct.
Okay. So earlier you said that you believe that the subject property was in contravention of the township's ordinances regarding rentals. So, and you're familiar with the different districts that the township has?
Yep.
So for the subject property, and what district is that in?
That's a residential district.
Okay. So to your knowledge, does the code of ordinances specifically enumerate uses for residential districts?
Correct.
Okay.
Are you moving for the admission of that document?
Yes, I'm sorry.
Any objection to that, Mr. Astin?
No.
Plaintiff's one or people's one is admitted. You may proceed. I'm sorry.
Forgive me. So. Now, to your knowledge, are there any districts within the township that allow for the types of business activities as in short-term rentals that the subject property was part of?
Yes, although it's not defined as short-term rentals in the ordinance, on Macomb Street districts and the airport district, bed and breakfasts are permitted through special land use, which is where this sort of transit sort of activity would be permitted. But that takes special approval through the planning commission.
So I have you straight. So transient use is permitted in certain districts, but not in the district in which the subject property sits.
Correct.
Okay. And so to your knowledge, was the violation ever remedied?
No.
I have no further questions. I reserve the right to recall a witness for rebuttal.
Thank you. You can proceed. Any questions?
No questions, Your Honor.
You can step down. Thank you. Call your next witness.
Time for calls. Zoning Administrator James Brown.
All right. I'm going to ask you to raise your right hand, sir. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. It's B-R-O-C-K, correct?
B-R-O-C-K, that's not true. You can proceed. All right, good. All right, thanks. So what do you do?
I'm the zoning administrator for the Roseville Township.
And how long have you been in the employ of Roseville Township?
About a year and 6 months.
Okay. So, as with the previous witness, I'm going to bring you back to honor about August 20th, 2025, Roseville Township, County of Wayne, State of Michigan. Something happened on that day that brought you here today?
That's correct.
Do we have, something happened on that day that brought you here today?
Yes, that's correct.
Okay, so please tell us why you're here.
We observed a rental, short-term rental going on at a specific address on Roseal, and we.
Okay, stop for a second. Is that for that address be 27595 Elba?
That is correct.
Okay, I'm sorry, is your definition of short-term rental, does that comport with the testimony from the previous witness?
That is correct.
Okay, go on, please.
So we had observed a short-term rental happening at this address that I mentioned before. We had sent multiple notices at this point to try to remedy this issue and make them aware of the fact that it was not something that was allowed to be done. And at that day and time, it was observed that it's still been up and running. And again, that is against our ordinance.
Okay. Can I move this quickly here? I'd just like to hand you a copy of Mrs. Exhibit A for the township.
Wait a minute. Exhibit
Sorry,
Exhibit A.
Did I say one the first time?
What did you have that first one marked, Tabitha? Yeah, so let's have this marked Exhibit 2.
This is the same thing. This is the same exhibit, Your Honor.
Oh, I see. Okay, so it's already been entered as Exhibit 1.
Yes.
That is what you have handed him.
Yes, Your Honor. I'm sorry. I didn't
That's okay. Is that true, sir? Is that what you have?
That is what I have.
Okay, ask your next question.
You're familiar with the correspondence that's in front of you?
That's correct.
Okay. Did you send or prepare these letters?
That is correct. That it's sent.
Okay. And 3 of them, correct?
Correct.
And each of them was sent because there was a violation of subject property, correct?
Correct.
And to your knowledge, was this violation ever remedied?
No, it was not.
Okay. No further questions, Your Honor. I would like to again reserve the right to recall the witness on rebuttal if necessary.
Okay, Cross? Any? You can step down. Thank you. Call your next witness.
No other witnesses for the township, Your Honor.
Do you have any witnesses, sir?
I do not.
All right, so you're just gonna argue, right? Everybody? Go ahead.
Your Honor, you've had a chance, to have relevant ongoing case law regarding short-term rentals in Roseal. You've had copies of the ordinances. This seems to come down to not a question of whether there was a property that was short-term rental, however one wants to determine. The question was whether in the residential district in which the subject property sits, whether that was permissible. And I know Your Honor knows, as you've read, Michigan courts have determined that when, aside from specific uses that are enumerated in municipal code of ordinances, if it's not specifically listed, then it's not permitted. Michigan courts have also agreed as that short-term rentals fall under the definition of motels, and specifically within Roseal, because this seems to be a sticking point. Transient uses are permitted in certain areas, but as you've heard and as Your Honor has read, those uses are within 2 specific districts: the Macomb Street District, then the Airport/Light Industrial District. The subject property is not within either of those districts, therefore it is not permissible for a short-term rental such as the property, how it's being offered and how it has been offered, and how it was offered on the date in question. That was permissible use. And so again, I respectfully ask this court to find the defendant responsible.
Thank you.
Thank you.
Any argument, Mr. Astin?
In Kaiser versus Casey Township, Exhibit 1, page 5, may I?
Sure. I believe that was attached to your brief.
Correct.
I read it. But you can go ahead.
The Supreme Court reaffirmed the propositions that the courts cannot sit as the zoning commission, and the people of the community through their appropriate legislative body, and not the courts, govern the community's growth and life. Zoning Ordinance Chapter 285.24.5, Community Development Director, Zoning Administrator, and other administrative officials, Exhibit 2, states, in carrying out their designated duties, All such enforcement officers shall administer this chapter precisely as it is written and shall not make changes or vary the terms of this chapter. Further, in ream, Spring Lake, Supreme Court docket 159-874 of 2010. Exhibit 3. Supreme Court stated that the courts must use definitions provided in the ordinance and must not search a field for meanings where the act provides its own. They said we must follow the definition provided in the ordinance. See Butterfield Theaters. We need not, indeed we must not, search a field for meanings where the act supplies its own. Plaintiff also refers to ream in plaintiff's case brief, but plaintiff's conclusionary statement, interpretation of single-family dwelling, holding that its definition expressly excluded motels and that such short-term rentals are motels, is incorrect. The court held that the ream property fit the Township of Spring Lake's ordinance definition of motel and not the definition of single-family dwelling. The ream holding is inapplicable to this litigation as defendant is not being charged for violating the Township of Spring Lake zoning ordinance. And two, the Township of Rose Hill must apply defendant's facts to its own zoning ordinance definitions. Township of Rose Hill zoning ordinance definitions, which must be applied to defendant's facts. Defendant's Exhibit 4, excuse me.
Yeah, are these all for me, Mr. Astin?
The court, yes.
Okay.
Defendant's Exhibit 4 is the zoning ordinance, Article 1. And it should be noted that Article 1 is 225 pages long. Exhibit 4 only contains pages 1 of 32, which are applicable, which apply to defendant's facts in this litigation. Zoning ordinance rules of construction, Chapter 285, 1.2A10, which is Exhibit 4, page 2 states, whenever a word or term hereafter applies in the text of this chapter, its meaning shall be construed as defined herein. Words or terms not herein defined shall have the meaning customarily assigned to them. Zoning ordinance single-family residential districts intent. It's Chapter 285, 3.1. Defendant's Exhibit 5.
Give these out. You keep them.
States the regulations concerning single-family residential districts provide for a residential environment consisting predominantly of low-density single-family dwelling units. Single-family zoning ordinance, single-family residential districts.
Do you have anything that says that they cannot regulate? That the township cannot have an ordinance that prohibits Airbnbs? Is that what you're saying?
There's no ordinance that if you let me finish here, the definition of dwelling unit in our zoning ordinance, which is Exhibit 4, page 15, states that a dwelling unit is any building.
Exhibit 4, page 15.
Exhibit 4, page 15, which would be on your, it's chicken scratch, but it's C, tab C.
Okay.
Dwelling unit, so single-family residential districts, the intent, which is Exhibit 5 says, regulations concerning single-family residential districts provide for the residential environment consisting predominantly of low-density single-family dwelling units. Single-family residential units, Exhibit 6, which is right here, permitted uses, says in single-family residential districts, no building shall be erected and no building or land shall be used except for the following uses. Principal uses, single-family detached dwelling units, meeting the standards of 285-3.4E. 3.4E pertains to the quality of construction, so it doesn't apply to this case. But it says single-family dwelling units. So then if we go back to the definition of dwelling unit in the zoning ordinance, which is again Exhibit 4, page 15, which is B on your tab, it states any building or part thereof containing one or more rooms, along with bathroom and kitchen facilities, designed as a self-contained unit for occupancy by one family for living, cooking, and sleeping purposes, either continuously, permanently, temporarily, or transiently. It should be noted that plaintiff states in its plaintiff's case brief, page 3, Article 2A, that no transient uses were permitted in the township's R1B single-family district. This statement is clearly a frivolous claim and lacks any legal merit, as transiently is included in the zoning ordinance definition of dwelling unit. And single-family detached dwelling units are permitted principal uses in single-family residential districts. Furthermore, the plaintiff also made this statement in the bottom of page 1 of its brief in support of plaintiff Groseal Township's motion for summary judgment and Groseal versus Isaac, case number 2020-1015-495-CC, which that court relied upon in granting plaintiff's motion for summary judgment. Plaintiff's attorneys cannot make the statement before these courts in good faith when the zoning ordinance definition of dwelling unit includes transient uses. Therefore, defendant is entitled to sanctions. So if I go on further, so we have dwelling unit, the definition which includes temporarily or transient. Again, Exhibit 4, page 2 defines or indicates the connected terms, conditions, provisions, or events may apply singularly or in combination. Or means and or. If we go to temporary use in the zoning ordinance definition, which is Exhibit 4, page 29, a use which is not permanent to the property and is permitted to exist for a specific reason for a specific period of time. If we go to use, which is also defined in the zoning ordinance, Exhibit 4, page 29, the purpose for which land or premises or a building thereon is designed, arranged, or intended, or for which it is occupied, maintained, let, or leased. Let is not a defined definition in the zoning ordinance, but Cornell Law School's Legal Information Institute, which is Exhibit 7, defines Defendant's Exhibit 7 defines let as a property law term that refers to the act of leasing and or renting out real property by a landlord to a tenant. Let has largely been superseded by lease in American English, although it remains widespread in British English. Lastly, transiently is also not defined in the zoning ordinance, but per the Cambridge Dictionary, Defendant's Exhibit 8, transient is defined as someone who lives only temporarily in a place.
I want to make sure you're giving him copies of all of these things too.
They're included in the brief.
Okay.
I apologize, but I can get these.
Do you have all these documents he's referencing?
Yes.
Okay, good enough.
Again, transiently is also not defined by the zoning ordinance per the Cambridge Dictionary. But per the Cambridge Dictionary, which is Exhibit 8, transient is defined as someone who lives only temporarily in a place, lasting only for a short period of time, temporary. Thus, pursuant to the zoning ordinance definitions, which plaintiff, defendant, and the courts are required to abide by, defendant is leasing a dwelling unit located in a single-family residential district on a temporary or transient basis, which is a permitted principal use. The zoning ordinance does not place any restrictions on a temporary or transient lease. Therefore, concluding, pursuant to the zoning ordinance, administrative officials shall administer the zoning ordinance precisely as it is written and shall not make any changes or vary the terms of the zoning ordinance. In addition, in Kaiser, the Supreme Court reaffirmed that the propositions that the courts do not sit as a super zoning commission and that the people of the community through their appropriate legislative body and not the courts govern the community's growth and its life. So based upon the foregoing, what the township is again trying to do in this litigation is amend the zoning ordinance by judicial fiat. The zoning ordinance does not place any restrictions on the amount of time a dwelling unit located in a single-family residential district can be rented for. The proper procedure for amending the zoning ordinance is for the township to hold public hearings on the matter and amend the ordinance if necessary after that public input. Wherefore, defendant respectfully requests that this court enter an order dismissing the charge against the defendant, awarding defendant his costs, and awarding the defendant any additional relief this court deems necessary and just.
Thank you. Mr. Wayne?
Yes. Your Honor, heard the arguments from the township, arguments from the defendant. We had an opportunity, court has, of course, to read the briefs and to read the applicable case law. And you have the factual underpinnings of the township's case as presented through the testimony of the zoning administrator and the community development director. Let this court know how this short-term rental was brought to their attention and their personal knowledge and evidence of the existence of this violation. I believe the township has satisfied its burden by the preponderance of the evidence that the defendant is responsible for violating the ordinance in question. So the township respectfully would ask this court to find the township's name. Thank you.
Thank you. Lisa, when is Grozeel back here?
They are back on November 5th and November 19th.
I'm gonna adjourn this to November 5th. I want to look at a couple things more closely, okay? I spent considerable time reading both of your briefs here, but I still want to go back. November 5th at what time? Let's make it later, 10:30, so Mr. Astin isn't waiting around, okay? So that'll be at 10:30 on November 5th. You guys can return and I'll tell you my ruling at that time.
Your Honor, if I may, does the court have this time any need to have any further testimony from the witnesses?
No, the witnesses don't have to return.
So this would excuse their appearance.
Oh, yeah. Right. They don't have to return. Nobody. Yeah. Okay. Thank you very much. I am giving both of you a copy of the exhibit. So you can approach up here, wherever that is, Tabitha, give them it. And we'll retain the original, I suppose. Okay.
Thank you, Your Honor.
Thank you. Antoine Torrance, 25B149389, A and B and C. And I also have 25B149398. And then I also have a sentencing here.
Yes,
On file 25B148681A. Sir, your name?
Attorney Mike Baldwin, House Counsel, just as to 898 B, C, and 98. Today is the date and time set for an arraignment pretrial for purposes of arraignment. On those four matters, my client stands mute and waives formal reading of the general information and complaint. We're asking that this be scheduled for a subsequent pretrial date.
Not guilty pleas are entered. We have a possession of a controlled substance, open end talk, super drunk. And no ops. I'm entering not guilty pleas on all of those. Where does your client work at?
I'll allow him an opportunity. I didn't see that. He's unemployed for 2 years. He received social security disability. He's also got to go before the forensic center. He's got a date of October 23rd tomorrow to report to a law firm. There's some judicial reason. It looks like he's in front of Bradley Cobb on a forensic appointment case. So it looks like he's going in for a forensic
I
investigation.
need a bond sheet.
Judge, on the 81A case, today's date time set for sentence.
I don't want to talk about that. I'm setting a bond yet, still.
Okay, yes.
He's got a horrible record. He's got a prior He's got a prior drug charge from 05. He's got a prior impaired charge from 12. He's got another drug charge from 25. He's got a jury trial scheduled on another drug charge next year. I don't know, you know.
First of all, he's showing up for every court hearing. I just want to make sure that I'm aware of. There was one bench warrant on the Register of Actions for 98, but because he was incarcerated. Yes, thank you. 81.
He had crack and marijuana. They're recommending jail.
They are. And Your Honor, we discussed this. He went in May of last year, May 29th, I think was the incident date. For reasons which I can't figure out, he was apparently not arraigned on my case. He wasn't arraigned until July 2nd. And
what case?
On the, this case that we're on, Judge, the 81 A case.
No, he wasn't arraigned until August 27th.
Well, there wasn't no.
He didn't show up on July the 2nd. He didn't show up on July 16. He posted a bond on July 30. He was arraigned on August 27th. Then we adjourned it to September 10th and the 24th. And then he pled on the 24th.
The rub is this. He was picked up on May 29th, the incident date. He went into Wayne County Jail on the 30th of May, and he sat in there for 2 months. And the question is, why wasn't he arraigned?
And that's why I didn't even know the court date. And
he was oblivious.
Well, he must have been on another case.
That's what I explained to my client that it looked like to me, but it doesn't change the fact that the incident happened on the 29th. He's brought into custody. So they know that there's this allegation of a controlled substance charge, and he's not arraigned, so he's sitting in jail without jail credit. We would ask that the court, and I'm going to respect my client's request, I'm going to ask the court to give him any jail credit that he's entitled to if this court.
Well, he's going to have to provide us with some proof.
That he was in jail?
Yeah, I mean, hang on a second. Slow down.
Now, my client is asking me to ask the court, and I will, for probation.
Well, I get it, but you know what I'm going to do? I'm not going to sentence him today.
And wait until we do the.
He can get his proof, but on this case, I'll give you a personal bond on this drunk driving. But you're not going to be released until you're fitted with a SoberLink device. Do you understand what I'm saying? Yeah, you're going to have to be fitted with a SoberLink device.
As a bond condition.
As a bond condition. So I'll give you a personal bond, but you're going to be, sir, you're going to be taken downtown, and you're going to remain in custody until they can fit you with a SoberLink. This is crazy. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. Slow down. Let me talk.
He wants.
Hang on. I'm not done.
Yes, Judge.
AANA 4 times a week, not to be released until fitted with a SoberLink device.
Yes, Judge.
What's the problem?
First of all, let me finish something.
And then I'll set a pretrial on this, and I'll set the sentencing date over on the other one.
So that, Your Honor, I'm going to just emphasize to my client, I know.
What does he want? He's agitating me right now.
I'm sorry, sir, but
what do you want?
He wants to go to his forensic appointment.
I'll get in trouble for this.
When is that?
Tomorrow. And that's what I was trying to say.
You don't have the money to get your own SoberLink.
I do have money. I have money, sir. If you could just give me another day, I could.
No.
Tomorrow after this appointment, so I don't violate my.
Looks like he's got to be at the forensic evaluation.
Here's the problem.
On October 23rd at 9 a.m.
He's going to have to deal with somebody else because, sir, I don't trust him. Knock it off. Do not argue with me. Otherwise, I'm setting a real high cash bond here. I am not about to argue with you. You're awaiting sentencing and you go and pick up a drunk driving. Your record's horrible. No wonder they're recommending jail. They do not give me enough money to argue with people, and I'm not starting today.
I'm sorry.
Have a seat. That's the order of the court. We're going to give them a new date, Lisa, as soon as we can on these. These are out of Brownstown. So what day do you want to give them? In other words, I'm adjourning the sentencing to that date and the pretrials on the other case.
Judge, my understanding is once he's fitted with the sober link, he's free to
Correct,
go against
correct.
personal bond.
Correct. Sir, shut up and sit down.
That's my, yeah, that's it. Yeah. You do that.
Go ahead, Lisa.
November 5th at 8:30.
November 5th at 8:30. Those are going to be the dates.
Yep.
Is J. Edward Clay here?
And Zoom, Judge, he's in the hospital, is my understanding.
He's in the hospital?
That's what I was told. I'm bringing him in right now. There's also a subpoenaed witness out there.
J. Clay, J. Edward Clay, 25I 76087A, B and C. Your name, sir?
J. Edward Clay.
Are you doing okay? They said you're in the hospital.
Yeah, I'm getting the treatment back. I had back surgery and I had got an infection, and I'm hurting. I'm in pain, actually, Doc. Your Honor.
Okay, are you in a position to proceed on this today?
Not really. I'm not, because they got meds in me, and no, I'm not.
Ma'am, are you, what's your name?
Mine?
Yeah, are you on this case?
Yes, I am.
What's your name?
Lisa Fell.
Okay. I mean, so you want to go with a hearing, sir? You don't believe you had anything wrong? I mean, you don't believe you're responsible on these?
I wanted to stand mute on it, Your Honor.
There's no standing mute. It's not a not guilty plea. It's a civil infraction.
Oh, okay.
If you want to have a hearing, we'll give you a hearing. But it's been going on quite a while. Ms. Day, please.
Yeah.
Thank you. It's been going on quite a while. I got to move this case on here.
Okay.
If you don't think you and the prosecutor can resolve something, fine, but
That is your acupuncture. You can try some Toradol to get the inflammation down.
Okay, thank you, Doc. Thank you. Okay, I'm sorry, sir. Your Honor.
Dad, got to move this case along. It's been going on way too long for me. I'm supposed to have these done like quickly. It's been going on for 2.5 months. Listen, if you don't feel well and you want to have a hearing, that's fine. I'll give you a hearing in 2 weeks. Otherwise, I think you and the prosecutor maybe can talk this over and see if you can resolve it.
Okay, yes. Can we do that, me and the prosecutor?
Have you talked to him yet?
Yes, Your Honor.
Your name?
Matt, wait on behalf of Istilart Township, Your Honor.
What is it?
We had an opportunity to speak. My understanding of Mr. Clay, again, he did not say this to me. It's my understanding, my interpretation, Mr. Clay is aware of his responsibility for this action. However, I understand that there's a possibility of civil litigation. That's what Mr. Clay represented to me, and then is hindering him from getting plea in this matter, or rather, coming to some kind of acknowledgement of responsibility.
I don't know what to tell you. What do you want me to do?
Can we just adjourn it? I can talk with the prosecutor the next couple of days.
Listen, I'll adjourn it. Why didn't you tell me that you had this going on?
I didn't. I had it done last week, and then this is the consequences of it. I've been in so much pain. I can't walk. I've been in a wheelchair, so I've been in the hospital, and they're trying to get me back walking.
Yeah, I can't speak to Mr. Clay, but as far as Ms. Fell, the victim, this is the second time she's been subpoenaed. She has hourly employment that she's missing out on as a result of this.
we received, we're talking about the court and we received indication. So Mr. Clay apparently did attempt to retain counsel as the original reason for the adjournment.
Then she withdrew.
Yes. Here we are, the date and time scheduled.
Yeah, I'm gonna go ahead. I mean, you seem fine to me. I'm gonna go ahead and proceed with this hearing now.
Okay, that's fine.
Okay, let's call, I have 25I 67608 A, B, and C. Lisa, you can move this day's court hearing date.
4 weeks from today, please. That was what the case was. Yeah.
Go down the hall and she'll give you a new date, okay? All right. Mr. Clay, your name again.
J. Clay.
All right, counsel, your appearance again.
Good afternoon, Your Honor. Matthew Wayne on behalf of Groseal Township.
All right. Do you wish to give an opening? I have 3 charges. I have no license, vicious act, and it says duty to notify police.
Just because of the risk of leaving.
What does that mean?
Kind of the injuries, Your Honor, and that's the circumstance.
All right, well, okay. So, Mr. Clay, do you want to proceed to the hearing or do you wish to admit responsibility to any of those?
I'm gonna proceed to the hearing.
All right. You want to just call your first witness? Do you waive your opening?
Yes, Your Honor.
Do you waive your opening, Mr. Clay?
Yes.
All right, call your first witness.
Thank you, Your Honor. The township calls Lisa Bell.
Ms. Fell, state your name.
Lisa Fell.
Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony you've given these proceedings will be the whole true self you got.
I do.
Okay, go ahead.
Good afternoon, Ms. Bell. How are you?
I'm good. How are you?
I'm fine, thanks. What do you do for a living?
I work as a delivery driver for Amazon.
How long have you been in the employ of Amazon?
2 years.
I'd like to take you back to on or about August 6th of 2025 in Groseal Township, County of Wayne, State of Michigan. Did something happen that day that brought you here today?
Yes.
Tell me what happened that day.
I was attacked by a customer's dog.
Okay, so if I go back for a second, so you were in Groseal Township that day?
Yes, sir.
Okay. And the time of the dog, the attack that you're talking about, would this have been approximately at 4:30 in the afternoon? Does that sound about right?
Yes, sir.
Okay. And if I told you you were in the vicinity of 28790 Coleman Drive in Groseal Township, does that ring a bell?
Yes, sir.
Okay. Why were you at that residence that day?
I was delivering packages to that address.
Okay. So you're in your delivery vehicle, correct?
Yes.
And you get to the residence. What do you do then?
I make sure there's no dogs on the delivery app. It'll notify us if there is. I gather the packages. I get out of the van, and halfway down the driveway. Yes.
So just so we're clear, we're talking about what happened that day at that residence, right?
Yes, sir.
Okay. Sorry, go on.
I got about halfway down the driveway when a dog just charged at me out of the garage.
So sorry, out of the garage, 28790 Coleman Drive. Okay.
Yes, sir.
What happened then?
I froze. I didn't know if the dog was going to attack me, or approach me friendly, but it just darted at me anyway. It jumped on me immediately and immediately attacked me, biting my leg. And I threw the packages down. I threw the phone down and I started screaming and I ran back to the van. About halfway to the van, I looked to see if the dog was chasing me. It was still where it bit me. So I assumed that maybe it had an electric shock collar on or something. But I got to the van and I was holding my leg, crying. I immediately started calling my dispatcher, and I heard someone asking me if I was okay, asking if the dog bit me. I came up to the front of the van because I had ran to the back of the van where I felt safe. So
If I
I
could
walked
stop
up
you
to
for
the
a
front
second.
and okay.
Sorry, Miss Bell, if I could stop you for a second. So you said the dog attack was the dog bit you.
I'm
Correct?
sorry, could you
The
repeat that?
dog bit you, right?
Yes.
Okay, go ahead.
How many times did the dog bite you?
He latched onto my leg and kind of pulled my skin. I'm assuming he bit me once, maybe nipped me a second time.
Did the
Or the
dog
other,
draw blood?
yes.
Did you perform any first aid upon yourself?
Sort of. The customer came out and told his son to grab some peroxide and paper towels. So I kind of cleaned it up a little bit.
Okay, the customer, is that individual on Zoom today?
Yes.
You can see names. What's the customer's name?
His name is Jay Clay.
And the person who's on the screen with the name Jay Clay, that's the same individual that was at the house that day?
Yeah. Yes, sir.
Okay. So you said there was some peroxide and some what?
Paper towels.
Okay. And what did you do with those?
I poured it on my leg and wiped off the blood and held it on my leg.
Why did you have to hold it on your leg?
It was just blood coming out.
Okay, so it wasn't like a little bit of blood, like a trickle.
No, sir.
How would you describe the blood coming out of your leg?
I would say pouring, but it was a little less than pouring. It just kept coming out.
Okay. What happened then?
In the middle of talking to my dispatcher and explaining what happened and talking to Jay, he repeatedly kept apologizing to me and telling me he meant to put signs up. And my dispatcher asked if he needed me to be taken to the emergency room or if I could drive myself. I told him I wanted to get there as soon as possible, so I wanted to drive myself.
Okay. And was that the end of the incident?
Jay then offered his contact information, and I took it down. I took his name and his phone number.
Okay. And then what did you do?
I left and I went to the first choice urgent care in Romulus.
And were photographs taken of your injuries?
Yes, I took them as I was on the phone with the dispatcher at the address, and then I took them at the urgent care. I took a lot of photos.
Okay. All right. No further questions. I would like to reserve the right to recall a witness.
Okay.
Thank you, Your Honor.
Do you have any questions of her, Mr. Clay?
No, I have no questions at all.
Call your next witness.
Dr. Call Julie Cordes.
Sir, do you acknowledge that the dog was not licensed?
You talking to me, sir?
Yes, sir.
Yes. I'm sorry. Could you rephrase?
That's all right. Raise your right hand, Ms. Cordes. You solemnly swear affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God.
Ready?
Okay, go ahead.
Afternoon, Ms. Sports. How are you?
Really well, how are you, sir?
Fine, thank you. What do you do for a living?
Animal control and evidence enforcement for Roseville Township.
And how long have you been in the employer of Bristol Township?
I think it's 13 years.
Okay. So I'd like to take you back to August 2025 in Jersey Township and County of Wayne, State of Michigan. Something happened that day that brought you here today?
Yes, sir.
Okay, tell me what happened.
In my recollection, I believe it was the following day that Lisa Fell came into the lobby of the police department to, report the dog bite. I recognized the name, Jay Clay. We had spoken before on another matter similar. Lisa described the incident as she did to you today. She.
Sorry, for a second, you said a similar matter.
Mr. Clay lives on the south end of the island, and I have been out there for a previous dog bite incident as well.
At his address?
Yeah, it was a couple of years prior, I think 22.
Okay. Do you recall whether that involved allegations of a vicious animal?
I'm not sure the term vicious was used, but it did in fact bite a neighbor, a young female, and there is a report on file. I couldn't remember if we had taken enforcement action at that time. I think the dog was younger possibly at the time, and we did do a report for documentation purposes.
Okay. So if this dog came in and filed a report, or if she wanted to file a report, want to make a report, so did you take that report?
Yes, I did.
Okay. And what was the ultimate result of you listening to her as to her account of what happened?
Basically, it was just documentation at that time. I wanted to meet with Mr. Clay and get his version of events. I do recall I took one photo in the lobby and we talked about her wound and how she was feeling that day. Was it better? Was she in pain? And she said that it was still bleeding, and you could see that it was bleeding through the dressing. So apparently it was a pretty deep wound.
Can I just ask a question? Did you check and see whether this dog that Ms. Fell was licensed?
Yes, sir.
Was it licensed?
No, sir.
Did Mr. Clay ever notify your office or you in particular of this dog bite?
No, sir.
She cited 20-14. It's actually 20-12, and it makes it incumbent upon the person who's bit by the animal or the owner to notify the police department. That's all the other information you need to hear. So if you can't get it from her and you want to get it from somebody else, fine. If not, that's fine too.
We'll just move on. That's all right.
Yeah, I don't really need to hear much more though, but go ahead.
So did you ultimately issue a citation to Mr. Clay? Is that correct?
Yes, sir.
Okay. And how did you present that citation to him?
In person, I believe.
Okay.
Not sure, but yeah, in person. And the reason for the multiple counts was because he had previously been informed to get the dog license. He had previously been informed to have the dog current on its rabies vaccination, which it was not either. And the fact that it bit another person and he didn't report it to the police department and left it to the victim to do so was where that third charge came from.
So what is your understanding, again, in your capacity as a code enforcement officer and someone who handles these types of issues on behalf of the township? What constitutes a vicious animal?
A repeat at large, so an uncontrolled animal. In this case, subjective, I mean, the dog was on electric fence collar, but who would know that? And there was no indication for Lisa to take any precautions, stopping her from reaching the front door. She didn't know there was a dog loose in the garage. Vicious, based on the severity of the bite, the picture of the wounds, if you have that available, it wasn't just a graze, it wasn't a single puncture wound. She said that dog latched down and held on. And
What kind of dog was this?
I think it's a pit bull.
So again, you went to the residence and then after that, so you gave Mr. Clay the citation, is that correct?
Yes, sir.
Okay. Okay. So no further questions, Ray, I would reserve the right to recall the witness if need be, Your Honor.
Any questions of Ms. Cordes, sir?
No, Your Honor.
You can step down. Thank you. Any other witnesses?
No, Your Honor.
Okay. Do you have any witnesses, Mr. Clay?
No, not at the time, Your Honor. I wasn't prepared. No, I don't.
See, what do you? You have any argument?
You heard today from the witness, you heard from the witness herself. If there's any question as to her credibility, you also heard from the code enforcement officer who testified regarding the injuries sustained by the victim. So no reason to doubt her credibility, and I think the township has met its burden.
Hold on, sir.
Lots of evidence.
Sir, do you have any argument?
No, I don't. I can't really hear. I can't really hear that good because my background is so loud. So I'm just basically.
Can you hear me now?
I can hear you good, but I can't hear the lawyers. I couldn't hear the officer Julie that well. So
why didn't you tell me when you were when you were listening? Why didn't you say something?
Because, Your Honor, I am in pain. I told you I was in pain from the beginning. So I didn't know we was going to do the hearing today. I thought we was going to do the hearing another day, and we were just going to adjourn it. But since you just started the hearing, if that was the case, I would have just pleaded out from the beginning. But like I say, I don't have no argument. You can move forward with your judgment, Your Honor.
There's not any question here, but that you're responsible of not having a license for the dog, having a vicious animal. And even though there could have been an objection, there was testimony you didn't notify the police department. So on file E, I'm finding him responsible, file C rather, 87C, I'm finding him responsible of a violation of 20-12, which is a duty to report to police. So I'm finding him responsible on all charges. Can you pull him up? These cases are going to all result. These are ordinance violations under Grozios Township Code. They're for civil infractions. So I'm going to simply, per our chart, charge 135 on each of these. So you owe $405. Ma'am, you can seek restitution, or you can have a lawsuit if you want. I can't really order restitution in a civil infraction case, okay? So I want you to understand that. Sir, do you have the $405 to pay today?
No, I don't have it today. I'll probably be still here in the hospital. Can you give me a week?
I'll give you until the 7th of November. Is that good?
Thank you, sir.
Listen, if you don't have the money, no problem. Call the court on the 7th or before, and I'll be glad to give you an extension if you need one, okay?
Thank you, Your Honor. I appreciate it.
Thank you very much. Good luck.
Thank you. Take care.
Thanks a lot. Are we done?
Who's got motions?
I'll do them later. All right. Thanks, you guys. Thank you very much.